Respondent number deleted the name, a specific name of the respondent number 2 to 4. Their designation has also been mentioned, so there is no require of a specific name of the respondent number 4 to 6.
With respect to defect number 6, right?
Yes.
Or baki sir?
All are defect removed.
You have removed all the defects.
All defects.
Who are respondent number 2 to 6?
To general manager of HR Kent, and all are related to general manager, regional manager and sales coordinator.
6 तो है ही नहीं इसमें, 2 to 4 है.
2 to 4 है.
अच्छा. State coordinator.
Lots.
Yeah, regional manager.
Lots. Designation has been mentioned, so there is no requirement of a specific name. So may kindly permit.
अब पार्टी आप क्यों बना दिए हैं specific name से?
Sorry, may kindly permit to delete.
Award है. Award है.
नहीं, award नहीं.
क्या है? What is the impugned action?
Termination order.
Termination made by?
Made by the assistant Pandey. Termination by the chairman of Kent. Respondent number 2.
Respondent number. ये जो company है.
जी.
What is the name of the company? HR Kent.
जी.
It's a state.
No, ma'am.
तो यहाँ क्या चीज़ के लिए writ फाइल करती है? How is this writ maintainable also? आपको डिफेक्ट इग्नोर करके कल के लिए रख देते, तैयार हो क्या ये हाउ इज इट मेंटेनेबल?
जी.
है ना?
जी.
और WPL लगा दिए हैं. How is this writ maintainable against private party?
कल कर देंगे मैम.
हाँ, थोड़ा कल करिएगा, समझाइएगा कि कैसे आप क्या ये रिट पिटीशन फाइल करेंगे.
जी.
टाइम मत मांगिएगा.
नहीं, टाइम.
ठीक. WPL number 6877 of 2023. The learned counsel for the petitioner submits that IA number 5760 of 24 has been filed for with a prayer to ignore defect number 6. The preemptory time to remove the defects is expiring today. And therefore the matter has been mentioned and has been notified. He submits that the respondent number 2 to 4 are the incumbent, are holding the designated post. And their designation would be sufficient. He submits that the defect be ignored. Considering the submissions, the defect with regard to the defect with respect to defect number 6 is hereby ignored for the present. IA number 5760 of 24 is accordingly disposed of. Pose this case on 22nd, 22 को तो ऑलरेडी 7 का डेट दिया हुआ है इसमें ऑलरेडी एक डेट दिया हुआ है
उसी दिन
Pose this case on 22nd July 2024. On that day, the counsel for the petitioner shall also satisfy this court regarding the maintainability of the present reputation.
And all other defect are also removed earlier.
Office note में
ठीक
कि surviving defect कितना है?
Passport case item 33, Denomination 869 of 2023.
Yes, petitioner. Yes, sir.
Primarily, the allegation is of adultery, and I am relying on page number 62 of the lower court records, which has photographs of my wife with the alleged person. The first photograph.
What is the date of this photograph?
This is within the period when I was married.
From where do you say this?
Firstly, the date you granted us, today was the only working day which we got to look at these files, because you granted us time for Tuesday on Friday and the courts were closed.
You saw the records. You just indicated on the last day that you wanted to place the
Yes.
WhatsApp chat.
Yes.
Okay, now you want to place the photograph.
Yeah.
Now you tell us from where do I gather what is the date of this photograph?
This photograph is part of the WhatsApp chat.
Okay, what is the date and who is sending to whom? What are the phone numbers? Have you stated so anything in your evidence?
That is what I have not got time to do that, because this record is I just saw it today.
आप देखिए आपके पास बहुत ज़्यादा काम है चलिए देखिए आप इसको 4:30 बजे 4:15 बजे तक का आपको टाइम दिए देखिए आपको जितना रिकॉर्ड देखना है आप देखिए चलिए
The photographs do not have the time mentioned in it.
ना टाइम है ना डेट है कैसे किसी को पता चलेगा
So we have
हाउ डू यू रिलाई ऑन दोज फोटोग्राफ्स
these photographs shows my wife with that person.
So, a lady might have an affair before marriage. Is there any legal bar?
No, it is during the marriage.
So that is why I am asking you the date.
So then to that has to be given via 65B certificate. I cannot requisition Meta or Facebook for the
We
time.
do not know. You see, in your evidence also nothing has been mentioned. And this is the ground why these WhatsApp chats have not been considered for your matter. Your matter regarding adultery and your divorce petition is pending, isn't it?
Yes.
Yes. Even a prima facie case you have not been able to make out.
That is why we
That-
have come for this revision, because there is a prima facie case of an
So
adultery.
how? Suppose there is a lady has an affair before marriage.
Yes.
Can it be a ground for denying maintenance? No.
No.
So therefore, the date of the photograph,
Yes.
right? The date of the photograph is very relevant.
It can only be substantiated by a 65B
Why
certificate.
did you do that?
Because firstly, this LCR is with me today only now.
You see, you can't have it both ways. You want to go through the LCR. You cannot improve the LCR, isn't
Yes.
it? Right?
Yes. Correct.
The ground mentioned in the impugned order for rejecting the WhatsApp chat is very, very clear. It has been mentioned why this WhatsApp chat and these communications have been rejected.
But that has a background to it. She's married to me for the last 5
ये
years.
आपसे नहीं सकेंगे हम.
She's married to me for the last 5 years,
So-
living separately, only in the city of the alleged boyfriend. I have continuously asked her.
She was working there at that point of time.
I've continuously asked her to shift to my city, where is the higher pay grade.
How can you ask a working lady to shift to your city?
She's in a marriage relationship.
So she has to give up her job and come to you.
I have been to a PG where she stays. There are people who have informed me about that adultery.
Have they come before the court?
That
Have
is-
they adduced any evidence? That is absolutely hearsay. Why didn't you produce them? That they have seen this lady, and the allegation is that they had seen that she went along with him. If a lady goes with anybody, you will have make an allegation of adultery.
But then there are these photographs which do not
Photographs
have
also, even if we take it on the face value, that does not suggest adultery. You know the definition of adultery?
It has to
Merely because a girl is hugging a boy, that doesn't mean adultery. You might have your own mindset.
She often alleges that I am the person who is incompetent to.
This is not there on evidence. We will go strictly by the records of this case. In revision, we cannot go beyond what is there on record, unless it is especially perverse.
There's the only option left is to me introducing more evidence in this.
No, yeah, we cannot permit that. You have your divorce petition. You adduce your evidence. You expedite that proceeding, right? And the moment the divorce is granted, then you can file a petition for modification of the order of maintenance. There are so many things you can do about it.
Then I think disposal.
Criminal revision number 869 of 2023. What do you have to say?
I'm looking for the OP number 2.
Yes.
Para 12, if your lordship may come to. The
Yes.
learned family judge has given a specific finding in respect of adultery. Para 12, if your lordship may see page 28, if your lordship may come to.
Yes.
Last 2 lines. Respondent has filed some photographs marked as Y series. I have seen the aforesaid photographs and found nothing objectionable on seeing these photographs. As per marked Y4 and Y5, some WhatsApp messages have been sent to each other. On perusal of these messages, it does not appear that petitioner so-and-so has sent messages to her boyfriend. So on this ground, it cannot be said that petitioner is having leading adulterous life.
Learned counsel for the party for state is not nobody for the state. The learned counsel for the parties are present. This petition has been filed challenging the order dated 2/6/2023 passed by learned court of additional principal judge, additional family court number 2 Dhanbad in original maintenance case number 172 of 2022, whereby the learned family court has directed the petitioner to pay rupees 10,000 per month to the opposite party number 2 till she is alive. The counsel for the petitioner, while assailing the impugned order, has submitted that the learned court has not properly considered the photographs and the WhatsApp chats which were marked as Exhibit Y series before the learned court. He submits that on this sole ground, the impugned order is fit to be set aside. The learned counsel has also, however, during the course of argument and upon a query made by this court, the counsel for the petitioner is not in a position to inform this court with regard to the date of the photograph and also the WhatsApp chat. He has submitted that in that case, the required certification in terms of Section 65B of the Information Technology Act was required.
Evidence Act.
Sorry?
Evidence Act.
65B of the Evidence Act was required to be produced, which, and for that purpose, the matter be remanded to the court for fresh consideration. Right? Anything else? That's all. The learned counsel appearing on behalf of opposite party number 2 has submitted that the impugned order is a well-reasoned order, and a divorce case and a case for dissolution of marriage filed by the petitioner is still going on. He has also submitted that the finding with regard to adultery has been given in paragraph 12 of the impugned order by stating that the petitioner had filed some photograph marked exhibits Y series and nothing objectionable was found, and as per WhatsApp chat, it did not appear that the opposite party number 2 had sent messages to her boyfriend. He submits that the learned court, upon perusal of the materials, has recorded the finding, which does not suffer from any perversity.
One more point, ma'am. As far as requirement of certificate in terms of 65B of the Evidence Act is concerned, the respondent is required to produce the certificate. Court is not required to call for the certificate.
The learned counsel has also submitted that it was for the petitioner to take appropriate steps for production of the certificate under section 65B of the Evidence Act. And otherwise also, the impugned order, being a well-reasoned order, does not call for interference in divisional jurisdiction of this court. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the only ground which has been raised by the petitioner in this petition, before this court during the course of argument, is with regard to allegation of adultery against the opposite party number 2. This court finds that the learned court has recorded specific finding in connection with the allegation of adultery as contained in paragraph number 12 of the impugned order, accordingly, which is quoted as under. This court has also seen the photographs this court has also perused the photographs which were placed on record before the learned court, and marked as Y for identification, and is of the prima facie view that on the basis of such photographs and finds that there is nothing objectionable. फिर आपस divorce नहीं effect हो जाए, and is of the view that the learned court has rightly come to the conclusion that the photographs, that nothing objectionable has been found on the photographs, so far as the WhatsApp messages are concerned. There is
Ladies, the photographs are if it is to be gone into detail, I must be given an opportunity.
I'm just recording whatever is recorded in the impugned order, and I will just see how will I protect it. from the perusal of the WhatsApp chat also, it is not clear that the opposite party number 2 had sent messages to her boyfriend. It is further not in dispute that these materials were considering the totality of the facts and circumstances. This court does not find any perversity or illegality with respect to the findings recorded in paragraph 12 of the impugned order with regard to the allegation of adultery. So far as accordingly, the sole ground raised by the petitioner during the course of argument that the opposite party number 2 was in adultery with a third person does not call for any interference by this court. So far as other aspects of grant of maintenance under section 125 of CRPC is concerned, the same has been duly considered by the learned court, and an amount of rupees 10,000 per month has only been awarded. No arguments with regard to quantum and other aspects of the matter has been made by the learned counsel for the petitioner in the present proceedings. Accordingly, there being no merit in this petition is hereby dismissed. So far as, however, it is observed that any finding recorded by the learned court as well as this court, while upholding the order passed by the learned court, will not have any bearing on the pending suit filed by the petitioner seeking divorce. Kafi hai?
One more liberty that if the suit is in my favor, I given a chance to.
That is always there with you. You just see section 1. ये होना जरूरी है, नहीं तो आपका सूट इनपक्वस हो जाएगा. मिस्टर मजूमदार का अपीयरेंस रिकॉर्ड करना है वो. अपना अपीयरेंस मेमो दे दीजिए प्लीज.
I give. He was there, no, just.
He was there in the morning also.
Password case item 38, WPL 1464 of 2015.
WPL number 1464 of 2015. Heard the learned counsel for the parties. The learned counsel for the petitioner submits that both the orders passed, both the impugned orders are perverse and they call for interference. While giving the factual background of the case, the learned counsel has submitted that one plant, namely Loyabad Power Plant, was taken over by deed in Bihar State Electricity Board and was transferred to the petitioner to Bharat Coking Coal Limited in the year 1972. However, the same was given back to Bihar State Electricity Board The Learned Counsel, in the year 1990,
Year is not mentioned of returning back to the BSc.
है हम देखें.
So that's page 24, paragraph 4, मतलब in year 1992.
In the year 1992. The Learned Counsel further submits that the he submits that at the time of taking back of the said power plant, there were 216 casual workers on the roll of the said powerhouse, and out of 216 casual workers, 214 were not taken back by Bihar State Electricity Board on the ground that there was an award passed by the central government in reference case number 27 of 1983. The Learned Counsel submits that the said award was challenged in CWJC number 3486 of 1993 within bracket R, and the award was set aside by order dated 40/8/2002. Thereafter, the matter was referred to arbitration tribunal, and the arbitrator was, and during the pendency of the arbitral proceedings, the parties entered into settlement, and the arbitral proceedings was disposed of in terms of the settlement. The Learned Counsel further submits that the award contained in Annexure 4, annexed with the supplementary affidavit, is dated 25/5/2009, and the husband of the petitioner, who was the concerned workman, husband of opposite party, who was the concerned workman, attained the age of superannuation on 30/9/2005, and therefore there was no occasion to continuation or of his service under BCCL, as the award clearly stated that only 107 casual workers of Loyabad powerhouse of Bihar State Electricity Board, who were continuing at that point of time in BCCL, and have already been ordered to be paid category 1 wages from various dates by the management of BCCL, will be deemed to have been regularized from the date of starting of category 1 wage payment with other consequential benefits. The Learned Counsel submits that since the concerned workman had expired, there was no occasion to apply such an award to the concerned workman. The award attained finality. He submits that the import of the award has not been properly considered by both the authorities, and accordingly, the impugned orders call for interference. That was his entire case. The learned counsel appearing on behalf of the opposite party while opposing the prayer has submitted that the learned controlling authority under the Payment of Gratuity Act 1972 has considered the materials on record and found that the husband of the opposite party number 2 was working at Sendra Barnstore Colliery at SDL and was SDL during the period from 1/4/1992 till November 1996, correct?
Yes, my lords.
Till November 1996, and
He was also getting wages, my lords.
and he was getting wages as per BSEB rate, and coal mines provident fund deductions were also made. And he came on BCCL roll in December 1996. And at that time, his status was in December 1996. It has also been recorded that from 1996, he was working in the said colliery and worked till the age of retirement.
Plus one more point, he was getting wages of category 1 as decided as per NCWA rules.
He also submits that the workman was getting wages of category 1 in terms of national coal wage agreement. He submits that since there is a finding, he submits that similar finding has been recorded by the appellate authority and the impugned order does not call for any interference. The learned counsel submits that even the records of BCCL which was produced before the authorities clearly indicated that the said workman was in the roles of BCCL and was working at the colliery. After hearing the learned counsel for the parties, this court finds that the application dated 21/2/2012 was filed by the respondent, wife of late Kudus, praying for determination of the amount of gratuity and issuance of direction for payment to the project officer Sendra Barnstore Colliery of Messrs. Bharat Coking Coal Limited within bracket hereinafter referred to as BCCL. The applicant had stated that in Form N and the annexures, her husband was appointed in 1974 and retired on 30/9/2005 and died on 26/11/2009 and had put in 31 years of service and had prayed for payment of total gratuity amount of rupees 3.5 lakhs. The petitioner had appeared before the authority and filed a written statement stating that Mohammed Kudus was actually employee of BSEB and was not taken in the rolls of BCCL during his lifetime. The dispute in connection with the dispute was ultimately referred to sole arbitrator, before whom the claim of workmen for employment numbering 177 of Loyabad power plant was referred for adjudication, and a settlement was arrived on 6/11/2008, and it was consented for those who were continuing in BCCL. It was also asserted that Mohammed Qudus was ex-employee of BACB and had attained the age of retirement on 30/9/2005. As such, he was not on the roll of the company and could not be a beneficiary of the award dated 25/5/2009. The witnesses were examined on behalf of both the parties. The witness on behalf of the applicant was the applicant herself. Who deposed that her husband was working as SDL Mazdoor in Sendra Banstor Colliery from 1980 and retired in 2005. And he used to work sometimes in Loabad powerhouse of BACB and sometimes at BCCL Colliery. On the other hand, the witness of the petitioner stated that the husband of the applicant was working in, also stated that the husband of the applicant was working in Sendra Basjor as SDL casual Mazdoor and came from the role of BACB as per arbitration award dated 25/5/2009. And reiterated the stand taken in the written statement with regard to the age of superannuation and with regard to age of superannuation on 30/9/2005, and the award was passed on 25/5/2009. However, the witness was duly cross-examined, and during cross-examination, he stated that the husband of the applicant worked from 1/4/1992 as casual labor. And it was a fact that since December 1996 till the date of retirement, he was getting Category 1 wages as per NCWA and other benefits from CCL. And it was also a fact that since 1/4/1992 till November 1996, he was getting wages and other benefits from BCCL as per BACB rate. CMPF deduction was made from the date he came on BCCL roll in December 1996. And at that time, his status was that of a casual Mazdoor. The controlling authority of under the Payment of Gratuity Act considered the materials on record and summarized the case of the respective parties, and ultimately, as under करिएगा page number 21 का last paragraph, and ultimately recorded his finding in page number 22. ये number 1 है यहाँ पर और ये number 2 यहाँ पर. This court finds that the controlling authority has recorded a clear finding on the basis of materials on record that the deceased employee was on the roll of BCCL since 1/4/1992. As the employer confirmed deduction of CMPF in respect of deceased employee from 1/4/1992, and the employer's witness during course of evidence also admitted that since 1/4/1992 till November 1996 he was getting wages and other benefits from BCCL as per BSAB rate. The learned authority also considered the service excerpts and Form F and observed that they itself confirmed that the deceased employee was working with BCCL. This court further finds that the list of workmen who were whose case was considered by the learned arbitrator, as well as the list of workmen who were granted the benefit, were never exhibited by the petitioner before the learned authority. However, the learned authority clearly recorded a finding that on the basis of materials on record, that the name of husband of the applicant was there in the rolls of BCCL, and also the statutory forms of BCCL, and also in the statutory forms of BCCL. The appellate authority also considered the materials on record and recorded following finding. ये पैरा 28 से पेज 28 का लास्ट से नंबर 3 एंड नंबर 4, ठीक है. This court finds that both the authorities have passed well-reasoned order considering the materials on record. The argument of the petitioner that the award has not been properly considered by the authority is devoid of any merits, inasmuch as a finding was specifically recorded that the workman was working in Sendra Basjor colliery, and his and the entries were duly made in the records of BCCL, and CMPF amount was also deducted and paid by BCCL. The statutory form also contained the name of the sole respondent in Form N. Statutory form है Form F की Form N.
Form N is an form for application. In Form F, it's name of wife of deceased employee.
The necessary entries were also made in the statutory form. In view of the aforesaid facts and circumstances, there being no illegality or perversity in the impugned order hereby and accordingly the present petition is hereby dismissed. There will be a lot of corrections. These are all recorded proceedings. Correction होगा but dismissal है, क्योंकि एक जगह हम देखे थे the exact.
I can show it.
हाँ, show me that.
Page 22 minutes if you're not sure.
I marked it also during the lunchtime. I could not see that.
Page 22 minutes, second paragraph, last 3 lines. It is also observed that since the applicant is the nominee in Form F.
Yes, that's right. ये तो हम लोग लिख ही रहे हैं.
Yes. And reference of Form N is at in the very beginning your lordship has dictated.
No, I just saw that the date on which this unit was transferred.
1992.
1992.
It is there at page 24 minutes. The paragraph 4.
I will incorporate that. Because once the unit is transferred in
Yes, ma'am.
1992, there was no occasion for
Yes, ma'am.
subsequent engagement.
Yes, but like,
Yes, के साथ record चाहिए.
Item, personal case item 48, WPL 2703 of 2018.
इसको खोलिए. Are you ready?
He's coming. Mr. Rahul Kumar.
By the time you can argue? Tell me. What was it? Let us see the impugned order first.
Annexure 8 at page 90.
Yes, kindly place it.
Yes.
The complaint, yes.
The instant complaint is filed by the complainant against an order of penalty dated 28/7/2015 passed by the OP, whereunder the complainant was reverted to the post of AG3D in initial pay of AG3D from AG2D for alleged misconduct during procurement of rice at Bihar State Warehousing Godown at Chhapra District, Saran. That a reference 138 of the 1997 was pending before this tribunal against payment of OTA at double the rate in respect of all employees of United Bihar region of FCI, and during the pendency of the said reference, service condition of the workmen has been changed, altered, without taking prior permission of the tribunal as required under section 33(1) of the ID Act. As such, a complaint under section 33A is filed before this tribunal for violation of section 33 of the ID Act. It is further case of the complainant that OTA is linked with basic pay of the workmen, and if basic pay is reduced, the entitlement of OTA will also be reduced, and the original reference is about OTA. Therefore, action of management imposing punishment of reduction to the post of AG3D in initial pay scale of AG3D is directly connected with the reference, and admittedly the complainant are concerned with the said reference. The complainant, while working as AG2 depot, this is on merit at BSWC.
That's right, we'll see that later.
Yes.
And then,
The issues have been framed
yes,
at page 105, bottom. top, the issues are there. After careful consideration of written
kindly refer to internal page because there is mismatch.
Okay. Internal page 13 of the
13 of them.
Okay, yes.
Whether the complainant is workman and the present complaint is maintainable, whether at BSWC Chhapra there was procurement of food grain on 25 and 26/3/13, the issue this is on merits, whether the complainant is guilty for misconduct, again this is on merit. So point 1 is only on maintainability. This says the complainant is workman under IDA. He is mayor clerk and his OTA is linked with basic pay, are admitted by the OP. There is no denial either in WS of the opposite party or in any documents. The complainant is entitled to get OPA, and pending dispute is about OPA is also not denied by the OP. Rather, the aforesaid facts are admitted by the opposite party. It is also an admitted fact that reference number 138 of the 1997 is in respect of all the workmen of Bihar region, and therefore admittedly complainant is concerned with reference 138/97. Due to the alleged misconduct, the complainant was placed under suspension on 8/4/2013 without serving any charge sheet, As such, alteration in service conditions started with effect from the date of suspension. The charge sheet was issued on 15/1/2014, and after domestic enquiry, he was reverted to the post of AG2 depot in the initial pay to that post. Since his pay was reduced, then his entitlement to get OTA is also reduced, and the said change during the pendency of reference number 138 of 97 is in violation of section 33(1) of the ID Act, and for any such violation, there is express provision to file complaint under section 33A of the ID Act, and if complaint is filed, tribunal has to adjudicate the matter as if it were a diffuse dispute referred pending before it. So on this issue alone, first the tribunal has completely mixed up that there are two parts to section 33(1) as well as 33(2). One is 33(1)A, if I may place the provision. 33(1)A is concerned
सीढ़ी
with
चल रहा है क्या? 33(1)A.
33(1)A. Now the two provisions are, first is 33(1) and 33
You read from 1.
from 1. During the pendency of any conciliation proceeding before a conciliation officer or a board, or of any proceeding before an arbitrator, labor court or tribunal or national tribunal in respect of an industrial dispute, no employer shall. So A is in regard to any matter connected with the dispute, alter to the prejudice of the workmen concerned in such dispute, conditions of service applicable to them immediately before the commencement of such proceeding. Now the court relies upon 33(1) without specifying it is 1A or 1B. Now 1A is a simple change in service, not by way of punishment, and therefore it uses the plural term then, because when there is a change in condition of service,
Something
it
like
will be
there is
across
a
the board.
punitive transfer.
Yes, anybody, if the rate is double the OTA, and if I say no, I will not even give you single rate, I will give you half your regular wage, and it will be across board, then that is a change of service condition. But to inflict a punishment for a misconduct, reversion to a lower post at the initial time scale of pay is absolutely outside 33(1)A, because it has no connection with the pending dispute, which is regarding the rate of overtime wages, whether it has to be paid at double the rate, because the
The
Bihar
dispute was whether it has to be paid or at what rate is
at
it is
what
to be
rate,
paid.
at double the rate or single rate, because there was a provision in the Bihar Shops and Establishments Act which said for overtime you have to pay double the rate. The Food Corporation of India brought its own circular saying no, we'll pay at the same rate we'll pay for the extras, but we won't pay at double the rate. So that was the dispute, whether it has to be paid at double the rate or
What is
at
the terms of reference?
reference 138. That is not there.
It is there in the LCR.
It has been mentioned in the award only, but
It must be there in the LCR.
Lordship,
How can such a case be decided without the terms of reference?
Lordship must have been there. Many cases have been decided because there were a spate of cases on 138/1997 regarding rate of OTA. Both parties, and the problem is that before the tribunal, the lawyers were divided. The union and the management's representative were contesting. So a lot of these things were not brought on record. In the written statement, I'll just check. In the written statement, there is only a reference. There is no reproduction of these. Not even in the award, final award. There is no reproduction of the terms of reference.
Anyway, then what
So,
happens?
33(1) so far as 1A is concerned, it says about a general condition of service which is not by way of punishment. If there is a general change in service condition, which if connected with the pending dispute, then there is a requirement for permission. It is not permitted. B is for any misconduct connected with the dispute. Discharge or punish, whether by dismissal or otherwise, any workman concerned in such dispute, save with the express permission in writing of the authority before which the proceeding is pending. So, therefore, there has to be a direct nexus with the connection, not just a concerned workman. The finding that he is a concerned workman in the previous reference is correct, but the misconduct is not connected with the previous reference, which is a general nature. It is regarding rate of overtime wages. Here, the punishment is for specific charges of recycling of stock, food stock, bungling of food grain. Therefore, it has no connection. It was not that we were not paying the overtime wages and there was a strike for which I issued a charge sheet. Then it could have been connected. But it was not connected. Now, 2 permits during the pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman concerned in such dispute, or where there are no standing orders in accordance with the terms of the contract, whether express or implied, between him and the workman, it does not say may not, it says may alter in regard to any matter not connected with the dispute the conditions of service applicable to that workman. So it is permissible to, for any misconduct not connected with the dispute, discharge, punish, whether by dismissal or otherwise, that workman. So both these things are permissible. It does, the word in the first was may not, here it is may. But there is a caveat, which is the proviso. The proviso says, provided that no such workman shall be discharged or dismissed. Here the other punishments are not mentioned. In the clause B, it was said dispute, discharge, punish, whether by dismissal or otherwise. But in the proviso, it is confined to discharge or dismiss unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer. Now, the third part is for protected workmen. Protected workmen are a group of workmen who are generally the secretary and the president of the trade unions. They are declared as protected workmen. There is a procedure under which there is, so this is not a case of protected workmen. So our case in the written statement also is that here the punishment is not dismissal, it is reversion and putting the workman to the initial.
So post facto action was also not required.
So 33 2B proviso is also not attracted.
So your case is 33 2B proviso is not attracted?
Not attracted. 33 1 is totally not attracted. There is no connection with the previous dispute.
33 1 completely.
Yes. Completely not applicable.
attracted.
1 is about service condition. This is not service condition.
Change of
simplicity.
service condition. This is a
punishment.
Punishment which has a bearing in OT.
Yeah.
Right?
No, punishment which has a bearing.
Which has a bearing
Which
because
it may have-
ultimately if the wages change,
Yes.
then the quantification of OT
Yes.
will change.
Yeah, that has been said, but the provision does not say the consequence should have connection. The dispute should have connection.
That's right.
So dispute is bungling of food stock. The concerned the dispute must be connected. The two disputes, the dispute relating to which or for which the punishment has been imposed, connected dispute is requirement. The consequence is not, the consequence is there that it is a reduction, it will be reduced, but it is by way of punishment, and the disputes are not connected, they are altogether different. This is for food grain shortage, bungling, that is for a general question is referred. There is absolutely no connection nor any allegation that because I raised this dispute regarding OTA, therefore I am being served
Which
with
all
this charge.
judgments are you relying upon?
One is this Blue Star Employees Union, paragraphs 4 to 6.
Blue Star employees.
I'll just pass it on.
This is para number?
Paras 4 to 6. And before I place the judgment, there's one more ground which we have taken and there is no finding that against the punishment there was a statutory appeal and review under the FCI staff regulations. On that also there is no finding. That he could have preferred review alternative remedy before going to the industrial court. There is the FCI staff regulations.
Once there is a violation of section 33, then under such circumstances, where is the question of sending him to alternative remedy and he shall challenge all that?
If he says
Because
yes.
the whole purpose of section 33 is to protect the workman.
Yes.
So we can't, linger the proceedings like that. If any such violation is there, he has a right to straightaway come to the court
But-
and then raise his grievance,
Correct.
isn't it? And it is a complaint, and then once such a complaint is made and it is found to be maintainable, then the case has to be decided on merits. There is no question of reverting the matter to the appellate authority or to the revisional authority or whatever.
Yes.
But of course, the point as to whether it was maintainable or not is.
So
requires
that
to
was
be done.
specifically raised also in the WS. Also,
Para 4 to 6, kindly please.
Para 4 to 6. A complaint can be made to the tribunal under section 33A of the Act if there has been violation or contravention of the provisions of section 33 of the Act, and if it is found that there has in fact been such a contravention, the tribunal can proceed to adjudicate the dispute contained in a complaint on its merits. The violation of contravention of the provisions of section 33 of the Act would be the basic question that arises for consideration, and before giving any relief to an aggrieved employee under this section, the tribunal has to find out whether the employer's action falls within one of the following prohibitions contained in section 33. One is if the dispute pending adjudication has nothing to do with the alteration in conditions of service of workmen in contravention of 33(1)(a) of the Act, or alteration of conditions of service of a protected workman. Two, discharges or punishes a workman by dismissal or otherwise for a misconduct connected with the pending dispute without obtaining prior express permission in writing of the appropriate authority. 3 is discharges or punishes a protected workman, again not applicable. 4, discharges or punishes a workman by dismissal or otherwise for a misconduct not connected with the pending dispute without complying with the provision of proviso to 33(2)(b). And then 5 says, thus the contravention of the provisions of section 33 of the Act is the foundation for exercise of the power under section 33A of the Act. If this issue is answered against the employee, nothing further survives for consideration.
That's right, that is the
Yes, that is the law.
Get pass.
So therefore this issue
What
is
about this?
that the Dorairaj also discusses the issues in paragraphs
Para 9,
paras 9 to 11.
kindly read. Yes.
Dorairaj 9 to 11 deals with 33(2) specifically.
33(2), yes.
In fact, it also traces the legislative history
That's
that
right.
it was brought by way of an
Yes, what do you have to say,
amendment.
respondent?
Yes, I will be only on to two aspects. Milords, may kindly have a look, Milords, to Annexure 1, the page 33, which is the complaint which was there, Milords, under 33. I'll just read the complaint, Milords, only 2-3 paragraphs of the complaint.
Page 33.
And page 33, Milords, the complaint is start, Milords. Milords, got that. Page 33, Annexure 1. Milords.
Yes.
Milords. The Milords, that the complainant, Milords, that the complainant is a workman concerned and connected to reference number, Milords, got that. I'm
Yes.
placing the first paragraph.
Yes.
And the service condition of the workman has been changed in gross violation of section 33 during the pendency of the said reference. As such, this is a complaint is filed directly before this tribunal under section 33A of the IDA. So, Milords, we will be only on 33A part 1, Milords. Part 2 will not be applicable with respect to me, Milords, because it is not a case of discharge, Milords.
Okay. So your
Milords,
case is 33
33-1, Milords.
1A.
A1, Milords.
33 1A.
A, Milords. Now, Milords,
The change of
the
service
change of
condition.
service condition to that extent, Milords.
Okay.
Because my learned friend is absolutely correct in the proposition, Milords, that the cases of discharge and dismissal, Milords, it is not applicable. The facts are totally different, Milords.
That's-
Now, paragraph 2, I am making a reference to that, Milords. Only 2-3 paragraphs I will place, and then we will come to the Milords award, Milords. That an order of punishment dated 28/7 is passed against the workman, whereunder both the workmen are reduced in rank from AG2D to AGD in initial stage of pay in AG3D, which is clear-cut alteration, Milords, this is very relevant. This is clear-cut alteration in their service condition, as neither the OP has obtained any permission as required under section 33(1), nor obtained any approval provided under section 33(2) of the ID Act. Therefore, the order of punishment is illegal and unjustified on this score. Milords, what will happen, Milords? Milords, suppose, Milords, a reference is pending in relation to the overtime allowance, Milords. The overtime allowance, Milords, is to be paid on the basis of my salary, Milords. Whatever I am getting, Milords. Now here there is a prejudice has been caused to my service condition because I was initially placed in the pay scale of, Milords, for example, 4600 grade pay or something to that extent. If I am reduced to the basic pay scale, Milords, that will be reduced from 4600 to anything.
What was the dispute? The dispute which was pending in the reference was the rate of overtime allowance?
Milords, the OT overtime allowance, Milords, is on the basis of the overtime which the workman is, Milords, performed.
It was
So
on
it has
at the
to be-
rate, whether it will be twice or whatever.
Milords, it was at the rate of the twice whether it has to be done or
Whether it has to be on the twice or some other rate.
or some other thing, Milords. That was the reference, Milords, to the best of, Milords, what we have gathered from the records, Milords. It was not in relation to the, Milords, the otherwise the one of the disputes in relation to OTA is in relation to, Milords, the working hours, Milords. It was not, it was only in relation to the rate at the which it was to be
So
allowed.
therefore, do you want to say that if there is a dispute in connection with wages,
Milords.
right? Suppose it is at the rate of the wage, that it has to be given at 100 rupees per day, or it has to be given at
80 rupees.
80 rupees per day. Then under such circumstances, no disciplinary proceedings can be initiated against a person,
Milords,
and the adequate punishment in terms of the work order. There could be a punishment to reduce the
legislation,
wages.
that is the reason, Milords, 33(1), Milords, provides that there has to be a permission, Milords. There has to be an approval, Milords. It cannot be, Milords, that there cannot be anything to that
So
extent.
therefore, in a case where there is a dispute with regard to wages, no disciplinary proceedings can be
Until
initiated
unless they-
against anybody
No, Milords,
in
it
the
can-
entire
Until
organization.
and unless, Milords, there is a due approval, Milords, in
No,
terms
therefore-
of the.
therefore-
That is
therefore-
what my respectful
So
submission is, Milords.
therefore, suppose there is a dispute regarding wages,
Milords.
right? Then under such circumstances, there can be no disciplinary proceedings
Milords,
against
will
anybody.
appreciate one thing, Milords. This 33, Milords, has been intended to, Milords, protect the workmen,
That's
Milords, from harassment, Milords. This is one of the factors, Milords, why this has been come and why this provision of complaint was made, Milords.
That's
Pending, Milords, the conciliation or to that extent, Milords. So what is there under 33, Milords? It says that there has to be an approval to that extent, Milords.
So
That is what I,
So let us assume that
Yes.
your proposition is correct.
Milords.
Then nobody can be proceeded against
Milords,
department.
with approval, he can be proceeded against. It is not like
At
that.
the time of making a charge, suppose there is an allegation of theft.
Milords.
Nobody knows what punishment is going to be imposed. It is only the charge memo. He will
No.
face the departmental proceeding, and then the employer will decide that what is the punishment is to be
Plus,
imposed.
if it comes to the knowledge of the employer that already a proceeding is pending, there's a conciliation before the learned court, labor court, or to that extent is pending before any tribunal for adjudication, the necessary approval in terms of is to be required.
Whether the charge sheet could be issued or it could not be issued.
So far, the charge sheet can be definitely issued.
If charge sheet can be issued, then where is the provision that to say that the approval has to be taken at the time of passing the punishment
No,
order?
it can be at any stage once it comes to the knowledge, once it is there.
Important is not what is the consequence. Important is whether the charge sheet itself was linked to the pending dispute. The punishment of placing the employee at a different level of wages is just an order of punishment flowing out of a charge sheet. If you say that the charge sheet could not have been issued, then I can appreciate that the entire proceeding could
an
not
employer
happen.
for issuance of the charge sheet or for suspension
No, there are circumstances where even
two
suppose
circumstances are only there to that extent, if there is a discharge or dismissal, only punishment mentioned under 33 is to that extent, I cannot go beyond that.
So therefore the charge sheet is not linked.
No, to that extent,
It is only the punishment which is linked.
That
right?
is.
Does it say that before
Millers,
imposing
may
a
kindly-
punishment,
Millers-
let's have a look at it?
May kindly have a glance to again page 33, section 33. Got that. During the it says during the pendency of any conciliation proceeding before a conciliation officer or board or of any proceeding before so and so, in respect of an industrial dispute, no employer shall, this is very relevant, in regard to any matter connected with the dispute, alter to the prejudice of the workman concerned, in such dispute the conditions of service applicable to them immediately before the commencement of such proceeding. So, it says, it cannot be before the commencement of such proceeding. So, as on the
And when it comes to misconduct, it is only confined to discharge.
that is not applicable because here, I have been brought to the initial pay scale,
33(1)(a), is it referring to any disciplinary proceedings?
No, but it says,
But here the punishment has been imposed as a sequel to a disciplinary proceedings.
because B says, for any misconduct
Yes,
connected with the dispute, discharge or punish.
that's right.
For any misconduct connected with the dispute, discharge or punish, B will not be applicable.
B will not be applicable.
That I can say.
A does not talk about a disciplinary proceedings.
A does not talk of the dispute.
Therefore, here is a case where the order of punishment is a sequel to a disciplinary proceedings.
Hmm.
A charge, it is preceded by a charge sheet.
A domestic inquiry
So
has also been.
therefore, in a case where a charge sheet has been issued and whatever farce domestic inquiry might have been there,
Look, what I respectfully submit, that the fairness of the domestic inquiry, had been tested on the touchstone of the
there is no question of the deciding on the point of fairness of domestic inquiry, because the very filing of complaint, the jurisdictional
issue is there.
issue is not satisfied. Otherwise, in a case of dismissal, the workman has got a
Yes,
right to go
naturally.
to the labor court,
In fact, I was
and
going.
then otherwise it will come only through the labor
There
union.
is one judgment also in Jaipur Zilla, that judgment of 2002, which says about this 33 that as a measure of victimization it cannot be used. But that also I have gone through, it's a case of discharge and dismissal only where it has been applicable. So for this part of the part is concerned, section 33A is silent with respect to whether it will be applicable in a case where domestic inquiry has been commenced. That is there, what I cannot improve at this stage, I cannot argue that. But so far the other part is concerned, it was a case where the fairness of the inquiry has also been tested on the touches.
We are not on the minutes. We cannot enter into the minutes.
I think this second recent judgment 2021, it examines the amendment by which the subsection 2 was incorporated because of the hardship, because there was an absolute embargo, and therefore the legislature in its wisdom included subsection 2, and it said that for other punishments except for the extreme punishment of dismissal and discharge, even though you can do it, the proviso was there, you have to go and simultaneously file an application for ratification of your action of dismissal and discharge, but the other punishments short of dismissal and even change in service of conditions when it is not connected with the dispute was permitted. So these are the paras 9, 10 and 11 in which it was also noticed by the Supreme Court that when the ID Act was enacted, Section 33 imposed a ban on employer discharging, dismissing or punishing workmen during pendency of proceedings before the tribunal or other specified authorities except for misconduct not connected with the dispute. By amending the
That's right.
so and so, the legislative scheme was also discussed and it was said that it is now permissible only if there is a dismissal or discharge, you still have to follow the
To
procedure
that
going
extent,
to
the
the
judgment, I'll just be passing a reference, it's Jaipur Zilla Sahkari Bhumi Vikas Bank Limited. That clarifies that it would be applicable in my respect, although I am going against myself. That clarifies the thing, it would be applicable only in case of discharge.
What is the citation?
It's AIR 2002 SC 643.
AIR
2002 SC 643 Jaipur Zilla Sahkari Bhumi Vikas Bank Limited. I'll pass on the reference.
It is a constitution.
It's a constitution.
It is on the scope of what is the consequences if the employer violates. It has been discussed in several decisions. Even my lord has passed a decision.
I don't remember.
That Mallots has
In
also
FCI
considered that.
in
I have
FCI
considered
matters
section
also.
33 in a number of cases.
That
In
Mallots has
DB also and single bench.
But
Because
here,
that-
this is a unique case where the application itself is under question because in all those FCI cases also dismissal was admitted and management had not filed approval application. But here,
The
the
facts are a bit-
punishment itself is other than dismissal.
Other.
So in those cases, the consequence is when you have not taken, then what will be the consequence?
Can you file a short note?
You can
Both of you? Right. Appearance record kariye. The counsel for the parties have concluded their argument. They undertake to file a short note with regard to the arguments which have been advanced during the court proceedings. You can do it by day after?
Yes.
Day after, by day after?
If 1 or 2 days, do we also have to include the merits also because there
No,
also
no, not minutes.
not merits.
We'll
Not
find a
minutes.
small one, Mallots.
Just a
We'll
small
file
one.
only on the issue.
Huh.
By
Only on-
Friday, Mallots, we'll file.
By Friday?
By Friday.
By Friday.
By Friday. And if it is required, if I need to go on merit, because I will post this matter on next Monday
On the issue.
at 2:15,
Yes.
right? If you file it by Friday, then I will have an opportunity to go through it. Suppose I feel that a further argument is required on the point of merit. If I'm not with you on the point of jurisdiction, then I will give you that opportunity. There is no problem about it. But you file it on the short point of jurisdiction. The counsel for the petitioner has primarily raised the point of jurisdiction. And the arguments on the point of jurisdiction has been heard, right? Pose this case for a further hearing on Monday. If required, I will indicate, I will not take you by surprise. That much I can tell you, for sure. A soft copy भी साथ में देने का. हमारे stenographers को strain मत करिए unnecessarily. Just provide soft copies also.
This case for financial item 4, WPS 3279 of 2021.
Me. Primarily, we not the fight for getting entire areas of the salary and retire.
Why this is listed before me? Is it an assigned?
It is a side matter, not one of the honorable.
Chal.
I did the matter. Short synopsis, not at the
Has been
entire
filed?
case. file and the judicial
You just
pronouncement.
tell us the contours of the case and then we'll
Yes,
proceed.
initially, my lord, the petitioner has been appointed in the Biscoman in the year 1984. 84 service has been confirmed. Thereafter, my lord, the Biscoman is facing acute immense financial crisis. And due to that very reason, my lord, the policy decision of the government, they are the entire service of the engineers, my lord, so many engineers, my lord, the civil, mechanical, all these things. Their services were transferred to other department. Like the petitioner, he was the civil engineer. The urban department, his service has been transferred. And then 94 service has been transferred. He joined in the urban department in the year 1990. And he rendered service works right from 94 to 2004. Different places. It has been incorporated. Now, my lord, it was the valid transfer and rehabilitation policy of the government at that time. In so many cases, my lord, the disputes has been raised in the Bihar state, my lord, implying, my lord. The matter went up to the Supreme Court. The transfer of the service, whether it is the simple deputation or it is the valid transfer. Now it has been set at rest by Honorable Abbot Supreme. No, it is the rehabilitation policy and it is the valid, and due to the legitimate expectation and test of fairness, my lord, no, it is not the deputation. Now I have found, my lord, in my synopsis, there so many judicial pronouncements, other employee, my lord, of the Biscoman, which will go to prove, my lord, that the service was not the deputation. Now they are
So
claiming.
they are to be treated as employee of state government.
State government. State government, and it went up and it was controversy was set.
What is the nature of relief you have sought for? They have.
My lord, for getting entire salary, my lord, the right from 2006 to 2007.
Salary?
Salary, arrear of salary. My lord. 2006 he has stopped getting salary.
Why?
My lord, but only disputing, my lord. You are not employed, you have been deputed, all these things. Then 2-3.
Did you not move earlier?
Yes, my lord. Earlier, one upon a time, my lord, my service has been transferred. No, you should go to the Biscoman. It has been challenged because due to valid policy decision, my lord, I have been transferred. Now, immediately it has been stayed, my lord, by this honorable. It has been annexed.
Where is that? Where is the order of
Yes,
state?
my lord,
And what is the date of transfer?
Transfer 1994, my lord, annexed to,
1994.
annexed to.
Where is the order of?
Yes, Lord. Now when he has disputed annexed in Lord at page 40, my synopsis kindly have it. 41 was the order, my lord, that has been challenged, and it was state, my lord, annexed from annexed E. Your lordship, my
No,
synopsis.
your synopsis is list of dates. I've got list of dates on behalf of the petitioner. Short synopsis along with list of.
My lord, but subsequently I was directed to file again, my lord, on 20 last.
Was filed in the month of December 2023.
21 minute again.
Okay, one more you have filed.
Yes, sir. Because it was not complete. This is how my lord, the petitioner was directed, and then subsequently it had.
I don't find it. दिखाइए रे इनको।
It was filed in the form of an affidavit.
Affidavit will not, but because some relevant document or some judicial
ये
pronouncement.
synopsis of argument affidavit में with such documents can it be filed? दिखाइए जरा उनको कहाँ पर है, खोज के निकालिए। Synopsis
yes,
of
yes,
argument is not a pleading.
Yes, Lord, but
Then-
of course there was the relevant document for that reason because it was incomplete, Lord, and there was this so many judicial pronouncements for that reason it has been.
Judicial pronouncements you can incorporate in affidavit, but no other document you can put it in.
Document, it is the judicial order, and for that it has been
Where
stated.
is it? Put it back in. 1994, yes, Mr. Garabati. 1994, a stay order was passed. When was
The
it?
service has been transferred.
Sorry?
He has been not transferred money, he has been deputed to state governments of state of Jharkhand at that time, in 1994,
By an order of deputation.
by order of deputation. For a period, and the rules of deputation is for a period only for 6 years. After in 2003, my lord, his services have been repatriated. Thereafter, he came before the court challenging that, my lord, there is a stay order for my friend is saying, my lord.
Okay.
And thereafter, my lord, in 2012, my lords, Viscoman has recalled all the employees who were sent on deputation. And there was subsequently there was an order of notice also, my lords, put on all the employees, including the petitioner specifically, to come and join the Viscoman. He has not given his appearance, my lord. Thereafter, his services have been terminated. That termination order has been challenged before the Honorable Patna High Court. The same has been withdrawn, considering on the two documents of Viscoman, where managing director is not the competent authority to dismiss the person, rather the board of directors has to dismiss the person. And thereafter, nothing has been brought on record what happened with respect to the dismissal of that person.
So dismissal order was set aside.
No, my lords, the order has
Then
been
the-
withdrawn.
Then the dismissal order is still there.
Still, the dismissal order is still there, but there are subsequent letters of the Viscoman, my lord, saying that managing director is not the competent authority. Managing director is not the competent authority of the same Viscoman, there are orders, they are also on record.
How is it possible? There is an order of dismissal,
I-
challenged before a court of law,
And the-
and ultimately withdrawn.
Withdrawn.
Then the authority will say that that is a wrongly passed order.
Board of directors is saying that he is not authorized to pass such an order. And that recall of the order employees who are deputed, that was still existing. He has asked to join the Viscoman, my lords, he has not never reported.
Where have you been working throughout? कहाँ काम कर रहे थे?
विश्वकुमार सारा नगर विकास में यहाँ पे urban
You have been throughout working.
throughout 94 so many departments.
No,
He is
just-
disputing that all these
just-
things
In municipal
because
corporation.
34 years period I have rendered service and it has come. Now he is disputing he is the employee of Viscoman. Annexure 2 kindly have a look to for a
No,
moment.
he is not disputing that. You are not representing Viscoman. Are you representing
ma'am.
Viscoman?
Then
You
state
represent state.
Milord, I have rendered service in this state.
He
Now,
says
annexure
that
2
you are
and I
not
will
a.
show all the Milord.
He says that you are not an employee of the state government.
Now he is disputing. He can say no.
Where is the
Yeah,
order? Where is the order by which you were sent to the state government?
And annexure 2 kindly have.
Check.
Annexure 2 my reader.
उसी को देखा.
हाँ वही सबसे पहले उसको देखा गया उसके बाद जो annexure 2 का और ये डेपुटेशन वर्ड को यूज करें इट इज नॉट द डेपुटेशन सिंपल डेपुटेशन
Let us read it.
यस
Simple or not simple.
नहीं
the
नहीं
word
सिंपल ये
deputation
नहीं
is
इट इज
deputation
वैलिड
only.
पॉलिसी डिसीजन इट हैज कम फ्रॉम द सो मेनी जुडिशियल decisions and for that reason when we
Let us see annexure 2. Does it
Annexure-
word does it use the word deputation? पढ़िए.
प्रेषक सरकार के उप सचिव बिहार पटना सेवा में प्रशासक विश्वकुमार भवन पटना सो एंड सो 20 सितंबर 1994 श्री राजेश कुमार झा एवं अनिल कुमार पिटिशनर सहायक अभियंता विश्वकुमार की सेवा उपलब्ध कराने हेतु निर्देशानुसार उपयुक्त विषय के संबंध में कहना है कि प्रतिनियुक्ति के निमित्त श्री राजेश कुमार झा एवं अनिल कुमार सहायक अभियंता विश्वकुमार की सेवा नगर विकास विभाग को सेवा उपलब्ध कराए इट इज ड्यू टू वैलिड पॉलिसी डिसीजन ऑफ द गवर्नमेंट एट दैट टाइम
इस ऑर्डर से तो कुछ वैलिड पॉलिसी डिसीजन
हाँ,
के
इसके
बारे में
बाद-
कोई रेफरेंस नहीं है.
हाँ इसके
अब आप
बाद
वो जजमेंट्स दिखाइए.
हाँ जजमेंट इसमें जो हम
इनका क्या हुआ? आप कौन है?
हम
Both
हैं
the petitioners are here.
अनिल कुमार नो सिर्फ अनिल
इनका क्या हुआ?
अब
राजेश
इनका
कुमार
क्या
झा
हुआ
का?
इसको दिखा
राजेश कुमार झा का क्या?
राजेश का तो मत पता नहीं है लेकिन इसमें एक जो हमारे साथ जो
एक
है
ही साथ में दो आदमी का ऑर्डर है, आपको पता नहीं है, ऐसे कैसे हो सकता है?
नहीं जो पता है उसको हम किए एक जो ऑर्डर है
आप भी बताइए क्या किए राजेश कुमार झा का? What did you do to him? Identically placed to some extent? Any idea?
He
एक-
have not been posted in Jharkhand after bifurcation. This is of the 1994.
Okay.
That should be verified.
इसमें जो थोड़ा सा देखा जाएगा
चलिए उसके बाद वो ऑर्डर दिखाइए
हाँ, हम
जिसके-
इसको ऑर्डर दिखा रहे थे। एनेक्सर ए मेरा जो सप्लीमेंट्री जो दिया हुआ है शॉर्ट सिनॉप्सिस में, काइंडली हैव अ लुक टू फॉर एनेक्सर ए 28। ये मेरा सर्विस कंफर्मेशन हुआ था 84, जिसमें मेरा नाम है, माय नेम फाइंड प्लेस।
आप बोले थे कि सिनॉप्सिस में जुडिशियल ऑर्डर लगाए हैं खाली।
इस एक रिलेवेंट सब डॉक्यूमेंट है फॉर द एंड्स ऑफ जस्टिस एंड नथिंग मोर।
बड़ा अच्छा।
कि चूंकि ये मेन रीड में नहीं लगा हुआ था, उसके बाद इसको फॉर कंक्लूजन ऑफ द
साथ में एक एंड्स ऑफ जस्टिस लगा देने से हो जाता है
नहीं, इसमें यदि ऐसा लग रहा है कि इरेलेवेंट डॉक्यूमेंट नहीं,
इररिलेवेंट नहीं लग रहा है। हम ये सोच रहे हैं कि ये जो आप पहली बार डॉक्यूमेंट 84 का इसमें लगा दिए हैं by saying that this is a synopsis of argument, do you admit this document? Do you have anything to say to this?
No instructions.
No, yeah, it is the document. It is not my document. It is the departmental
And
document.
how do we know that it is not a forged document? It is a proper document. It was not cancelled.
Then Milord, he can dispute it. Milord. It is the
I don't know
because
what
Milord,
he will
in
do.
reference of that Milord, I am only coming Milord. Kindly have a look at Annexure 828 Milord. Sri Satyendra Kumar, Arun Kumar, to my name finds place Anil Kumar. Mr. Milord. Satyendra Kumar's case Milord was considered, and kindly have a look to Annexure P, 29 page. इनका संकल्प जो रेजुलेशन होता है इन द लाइट ऑफ ऑर्डर पास्ड बाय ऑनरेबल पटना हाई कोर्ट Milord.
You read it. You read annexure A.
A Milord.
A.
State में I am reading Milord.
आप पढ़िए ना.
In pursuance of Executive Committee's Resolution number 9 dated so and so duly confirmed by the Board of Directors in their meeting on 29/3/1984, the service of the following assistant engineers are regularized in the pay scale of so and so plus usual cost of living allowance and other allowance admissible in Biscoman from time to time with effect from 1/4/1984 as per Executive Committee's resolutions cited. Above, the assistant engineers are given only regular pay scale, but their services shall be purely temporary and liable to be terminated at any time without assigning any reason. And Lord, the names were given. Lord, thereafter, Lord, when the valid policy decisions, the case of Satyendra Kumar Singh, Lord, kindly have look 29 at the following. Lord, he was also transferred with me, Lord, in the urban department. Now matter went up to the Patna High Court.
Where is the order of LPA?
LB Milord, I have annexed. I have annexed to
पढ़िए order of LPA पढ़िए. Follow up order मत पढ़िए.
Milord, at page 42, kindly have a look. To entire things was dealt with by, of course, Milord, by the single bench. It was confirmed by Honorable this order. Very detailed order has been given regarding the employee of the district. At page 42, kindly have a look.
ये जो एनेक्शन ई में है पेज 40, इसका क्या स्टेटस?
हाँ, इसका स्टेटस ये हुआ, ये it has been stated Milord. Thereafter Milord, they came with one supplementary affidavit कि हम लोग इसको रेगुलराइज कर रहे हैं. ये इसमें उसके बाद हमने विड्रॉ कर लिया वो केस को. ये काइंडली हैव अ लुक टू इनका जो इस केस में जो स्टे हुआ था फाइनली कि हम लोग इसको कर रहे हैं, अब इनको रेगुलराइज कर देंगे. इट हैज कम इन दिस सप्लीमेंट्री एफिडेविट इन दैट वेरी केस. एंड देन मिलॉर्ड इट हैज
This was passed in the case of Anil Kumar. Are you Anil Kumar?
हाँ, यस
This was your case.
यस.
This was stayed on the ground that there is no corresponding post in this command.
Thereafter, Milord, I was doing work, Milord, in the state of Jharkhand, and thereafter, Milord, it has come in the counter affidavit. Kindly
नहीं
have a
आप
look.
LPA का order पढ़ें.
हाँ, इसको पहले हम सिंगल जज का पढ़ दें या LPA ही का पढ़ दें? It is
आप
the
जहाँ
detailed order. It was
जो
only-
आपको मन हो वो पढ़ें. बताइए.
delay of 2000 at page 10 minute 53. यही कंफर्म हुआ सिंगल जज का ऑर्डर को जो यहाँ कंफर्म किया गया. Delay up to 05 days in filing of the appeal is condoned, keeping in view the decisions rendered on so and so. 608 was the lead case of the LPA, and consequential consideration thereafter. Again on 16/3/2017, LPA number 344 of, we are in full agreement with the observation made by the learned coordinate based on 16/8/2017, while considering LPA 344 of that issue with regard to repatriation. Repatriation का हमेशा इन लोग कर रहे हैं कि repatriate करते हैं, but it was not considered. To the respective status does not warrant any reconsideration. Now and as the matter stands settled way back in 2010 in LPA number 608 of 2006, the order passed by learned single judge requires no reconsideration.
Where is LPA number 608?
608 I have not annexed 608 because the detailed order the single judge coordinate bench
We
order.
do not know what happened in 608.
Then the 608 can be also placed because it has been 608 was dealt with by the single judge. I have annexed.
LPA number 608, where is the findings of the LPA court? A case can be dismissed with a different finding, isn't it? Where is it?
608 was because it was dealt with the 608 and the
608 was this CWJC number 7440 of 13 was the subject matter in 608.
yes.
इसमें क्या है finding?
अब इसमें जो किसमें जो
Writ में.
रीट में यही है कि
पढ़िए.
इन्होंने hard learned counsel for the petitioner, learned counsel for the state. In this case, the petitioner in the first instance has filed an application with a prayer that the writ of mandamus be issued, commanding upon the respondent authority for his absorption against the post over which he has been discharging the duty in the department or against any other appropriate place taking into consideration the law propounded in CWJC number so and so, Bihar State Government implies so and so. The petitioner was working in the Bihar State Cooperative Marketing Union for his rehabilitation. He was deputed in National Savings Department Government of Bihar and in the office of Deputy Collector Director Koshi Division Saharsa. After a long lapse of time, the government has taken decision to repatriate the service of petitioner and other in their parent organization, that is Biscoman. Felt agreed on the reason that the Biscoman is a defunct organization. On that account, the petitioner was brought to the service of the state government, that is Department of National Saving, the Root Division. Is a wing of the finance department. The state government writes letter so and so 1999 decided that those who have been sent on deputation on or before 16/11/1999 will not be repatriated. It is a very important thing. From their parent organization, the government would absorb them, but those who have been sent on deputation after 16/11/1999 would not make claim for absorption over the post on which they are kept. In support of the contention, the counsel for the petitioner has placed reliance on a judgment of this court passed in CWJC number so and so, where this court in different paragraphs dealt with the issue in following manner. The respondents themselves have absorbed service of similarly situated employees as per Annexure 7 series, Annexure 8. Now they cannot deny same benefit to the petitioners who have worked for such a long time with legitimate expectation of absorption. Petitioners have annexed the order passed in CWJC number so and so, Annexure 10, whereby in the similar circumstances surplus employees of the Biscoman were directed to be absorbed. Counsel for the petitioners have also brought before this court the order passed in a batch of later patent appeal prepared by surplus employee of Biscoman and other boards, corporations who were going to be repatriated to the parent department and whose applications have been dismissed by the single judge. All these later patents appeal were allowed with a direction to the respondent to absorb their services permanently in the department they were working on deputation, subject to this condition that they were brought on deputation prior to cut-off date of 16/11/1999. The state government preferred SLP before the Honorable Supreme Court against the order passed in all the LPS, and the same was dismissed. I find that all petitioners who are members of petition number 1 association as well as other petitioners stands on similar footing as appellants of LPA number 608 of 2006 and its analogous appeals as such entitled for similar relief. Accordingly, the respondent number 2, 3, 4 and 5 are directed to pass necessary order of absorption of all these none of the petitioners shall be repatriated to those defunct boards, corporation, public sector undertakings, enterprises, which were their parent department. Petitioner will be allowed to superannuate from the post they are working. They will be paid their salary, pensionary benefit remaining on the same post. The order of single judge was challenged in LPA number 1831 of 2011. The state of Bihar and so and so and so and so. There the division bench affirmed the order passed by the single judge, and so what? So that
In
this
the
issue
entire writ petition, you are seeking a mandamus.
yes.
Nobody has considered these grievances,
No,
these
no, no,
facts.
not at all. No,
So
not-
somebody has to consider it. So how do we issue a mandamus straightforward?
Lord, in-
Somebody will have to consider his grievance, whatever it is. He's saying that that various employees were sent on deputation, but ultimately there were certain directions, some policy decisions, and pursuant thereto they were absorbed. There was a direction for absorption, and this deputation was of no use altogether. So this particular aspect of the matter, in the light of these circulars or decisions or whatever, is required to be considered by somebody.
These are the judgments of the Honorable Patna High Court. The same issues after the bifurcation of the state of Jharkhand they have raised, and the Honorable Jharkhand High Court held in a different way.
That's right.
You know, I have also explored this honorable court, my lord, what has held in different employment. I have an expert. When it has been confirmed by the
In this court, the judgments which were passed were in relation to the persons who were seeking mandamus.
Yes, my lord, and on that very ground, order passed.
They were seeking regularization.
No, regularization, salary, etc. my lord, I have an expert. The order
In
passed
this
by the
case, my lord, there is no specific order of either absorption or regularization of the present additional members.
Annexure
And
C,
the
kindly have a
parent
look
lien is
for
with the
honorable
Bismarck
court.
on the Amazon date.
You see, I think that where is that order of the High Court? Which it has attained finality?
My lord.
Because straight away mandamus, I just don't understand. Somebody has to consider and give a finding, and
No,
then
no,
we'll
it
see.
is not bearing not in this case.
May I place this case? Also, it's a short order, my lord. Sorry.
Yes.
This is the honorable division bench of this court. Third learned counsel for the bill. This court has already taken a view in similarly situated case which reads as follows. A person on deputation cannot claim right to absorption because his lien continues to be with the original department, and the department where the person goes on deputation may and may not choose to absorb. There being no statutory provision, the appellant has been asked to come back to its original post. It cannot be said that any illegality has been committed because none of the conditions of service as issued to him at the time of recruitment gets attached to that. Today, the learned counsel for the appellant has drawn our attention to Section 74 of Bihar Reorganization Act and has emphasized that the employees of the erstwhile government of Bihar are required to be dealt with according to Section 74 of Bihar Reorganization Act. We have no quarrel with the proposition. The section says that employee should continue to enjoy his post which he held. The appellant has held a post with Biscoman on substantive appointment. What he wants to say by this appeal is a deputation arrangement. We are afraid that deputation arrangement is not covered when he is a substantive employee of a state in terms of Section 74 of Bihar Reorganization Act. The learned counsel also emphasized that there was a ministerial decision. We have seen the decision was a proposal by a single minister with the noting that the proposal has to be put up before the cabinet, and the matter was never put up before the cabinet. Therefore, the single minister's decision cannot be considered as a decision of the government. Learned counsel has said that the Bihar government has acted upon the decision, but that cannot make an instance which is binding because it is for the executives to make a decision and follow them. Maybe the decision is legal or illegal. When it is tested in the court, the test has to be passed. We find both those decisions are not being a decision of the cabinet. They cannot be treated a decision taken by the government. Learned counsel further submits that after 2000, the appellant has been continuing and it should be deemed that Jharkhand government has acted upon those decisions, and the present litigation shows why appellant continued. In view of that matter, the argument is also of no significance. The questions of legitimate expectation and promissory estoppel were also raised, but we do not find any material available before us which would constitute these two legal grounds in favor of the appellant. In that view of the matter, they are just a kind of argument which are being raised for the purpose of being raised only. Learned counsel submits that Patna High Court judgment was upheld by the Honorable Supreme Court in SLP, and that makes it binding on this court. We are afraid it shows the ignorance of the learned counsel about the law because any SLP may be dismissed in limine by Supreme Court upholding a
You
decision.
see, I'll just observe that the core of the dispute is whether the petitioner is an employee of Biscoman or he is an employee of the state government. His specific case is that pursuant to Annexure 2, he was placed before the state government and he had continued to work. And your case is that he was repatriated to the department and he did not join. But on
And the department also called for him to attend that.
and the department also called for him. But these are the absolutely factual aspects and he's seeking a mandamus. We will not decide it. You just tell us who is that authority who will consider all these aspects of the matter and pass it on.
My lord, in my writ application, earlier writ application, my lord, the counter affidavit has been filed, my lord. And they have accepted, my lord, we are going to
No,
absorb.
we will not. You are seeking a mandamus
My
straight
lord,
away.
but the factual and the legal aspect.
No,
can be
no,
looked
in the
into.
counter affidavit, if they make a statement, that is not a decision.
No, no, my lord, and now the conduct, my lord, the state government's
No,
conduct, my
we
lord,
will
I
not
have
go by
read
the
that service
conduct.
law, now he is
We are
telling
not
me-
inclined to issue a mandamus like this. Somebody has to examine the records and the consequences of the various decisions,
Because, you
the
know,
various
the-
documents. Every person has a different set of documents altogether.
My lord, the conduct, my lord, the law of estoppels, my lord, he
Estoppel,
has,
we will.
my lord, he has released
Yes.
24 lakhs, my lord, and then
Must
it
have.
has been done. I have annexed, my
You
lord.
tell us
May I place
who
one
will
more?
consider it.
No, I want to place with regard to the question my lord says. I'm placing one more judgment. This is WPS, sorry, my lord, not LPA. It court, my lord, coordinates Anil Kumar Sinha, my lord. Paragraph, page number 7, my lords, point 2, my lord. The question framed, the same question the court has already. Internal
Page
page
number?
7, my lords, page 7, point 2, my lords.
Point 2.
My lords. The question, I'm reading now. The question as to whether the petitioner can be treated to have retired
Page
as.
number 7 is something else. Internal page 7 of this statute.
Well, that is LPM.
LPA 67 of 18.
I'm sorry. This is the, I'm sorry.
You have another copy for yourself.
My lords,
Page number 7.
page number 7.2, my lords. Here, this is with respect
Yes,
to
yes.
the same Bihar State Sugar Development Corporation Limited Board, my lords.
Okay.
The question as to whether the petitioner can be treated to have retired as state government employee is the moot point to be determined so as to enable the petitioner to get the pensionary benefits. The petitioner has laid reliances on Annexure 4 to where the order has been passed for adjustment of the number of employees where the name of the petitioner also finds place at serial 5, but the supplemental counter affidavit filed on behalf of the respondents dated the word Samanjasya and Samyojit have been interpreted to be adjustment but not absorption. In the writ petition, the word adjustment absorbed for the word Samanjasya and Samyojit
Samanjasya and Samayojan. Samayojit.
Samayojit has been used on the proper meaning of aforesaid manner and not absorption. Therefore, the word Samanjasya and Samayojit is used in Annexure 4 denotes the adjustment and not absorption. Moreover, the petition is admittedly an employee of the Bihar State Development Corporation and not an employee of the state government. The circular so and so is also clarified that the employees deputed from different boards, corporations and bodies of the state offices are not employees of the state government. Since the petitioner is not a government servant, he will not be covered under benefits of post-retirement benefits.
You see, my
It is not bearing, my lord, the
my
discussion.
only observation is
There are from
that these are the facts which are required to be considered as to whether the petitioner is an employee of the state government or he is an employee of the this government. And in an order discussing all the aspects of the matter, if the authority comes to a finding, then certainly you have a case to come to the writ court and challenge that order. But in absence of any adjudication by the authorities and you are putting in so many documents, why should this court appreciate these documents at the threshold?
Not the representation, I have, but he did not any disclosure.
अभी डायरेक्शन देते हैं.
तो हजूर इसमें मेरा एक कनेक्शन 32 देख लिया जाए जिसमें ऑर्डर वाइट हैज बीन कंफर्म्ड.
देखिए जहाँ मैंडेमस होता है ना वहाँ क्वाशिंग का ऑर्डर टाइप
नहीं क्वाशिंग नहीं है इसमें तो मैंडेमस ये है कि टेकिंग इनटू कंसीडरेशन माय रिप्रेजेंटेशन इट वाज नॉट डिस्क्लोज्ड ऑफ इवन इंटायर
Where is that
at page 32 the coordinate bench of this honorable court has passed the order. It has been confirmed by the LP court.
32. I'm just asking you, where is your representation?
Or representation annexure.
Annexure 25.
Ah, yes. Last.
This is because before the secretary
Yes.
asking him to treat you as your employee.
Yes, Lord, the state government.
As is
employees. Right from 94, Lord, till my retirement, that is 2017. and arrears of salary, my lord, that is 2006. He has stopped giving me, my lord. Even the amount has been released, my lord, to 22 to 24, my lord, kindly have a look, 23. 22 to 23 kindly have a look. 26 लाख रुपया रिलीज किया और वापस ले ली विदाउट ट्रीटिंग मी माय लॉर्ड एम्प्लॉय और ये मेरा जो मेन रीट जो फर्स्ट रीट था दैट इट हैज बीन कंसीडर्ड इट वाज एक्सेप्टेड कि वी आर गोइंग टू जस्ट एब्जॉर्ब आप इनका एज पर ओन व्हीम एंड कैप्रिस दे आर डूइंग ऑल दिस थिंग्स लॉर्ड ये अब तो आप कर लिए काम और
Who
उसके
would
बाद
be the appropriate authority to take a decision on this?
Secretary members,
Secretary of the department?
urban department.
even in contempt proceeding lord in one of the case he has appeared lord
We are not concerned with other
No,
cases.
no,
We are
no.
only concerned with your case.
Yes,
It is
but
not a
it is
PIL
there-
and no such order can be passed covering all the employees, right? We will consider only your case. Should we take the assistance of the finance department? Required, not required?
First, he should be absorbed, my lord. Thereafter, the finance comes in.
He is seeking absorption.
He has not prayed for that, my lord. That is the
That
issue.
prayer is not there.
My lord, that is
No,
the issue. Unless he is prays for absorption, still his lien is with Viscoman only, my lord.
under the valid annexure 2 my lord my service has been transferred.
Likhi. WPS number 3279 of 2021. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. It is the specific case of the petitioner that wide annexure 2, the services of the petitioner, it is a specific case of the petitioner that petitioner was initially appointed under Biscoman, uska full form de dijiyega, and by annexure 2 issued by the Urban Development Department, the then state of Bihar. The services of the petitioner were directed to be placed on deputation to the state government. The learned counsel has submitted that. Thereafter, the petitioner continued to work with the Urban Development Department
Till retirement.
even after bifurcation of the state of Jharkhand. And he attained the age of superannuation while working with the Urban Development Department of the state of Jharkhand on
30th 4 2017 not
30/4/2017. He submits that in spite of, he submits that the other employees who were similarly situated and their services were placed initially on deputation with the state government were ultimately absorbed by the state government and were treated to be state government employees and post-retirement benefits were paid to them. But so far as the petitioner is concerned, the post-retirement benefits is not being paid on the ground.
Arrears of salary.
Just a moment. The post-retirement benefits is not being paid on the ground that the petitioner is not an employee of the state government. He submits that the petitioner has not received salary from
2006 not
2006 onwards. And इस समय कौन आपको सैलरी दिया था till 1990 till 2006? Who paid you the salary?
state government. State.
Okay.
State.
He has submitted that the state government has paid the salary of the petitioner till the year 2006. He submits that the financial condition of Biscoman was poor, and therefore the employees of Biscoman were being placed in the services of the state government
Under different.
And by different orders, and were ultimately absorbed and retired as state government employees. Yahi hai aapka
Yes.
case? He has relied upon various judgments passed by this court as well as Honorable Patna High Court.
Supreme Court also not there. Apex Court of India.
he has also referred to one judgment passed by the Honorable Supreme Court in SLP number.
SLP number. Special Liquidation Civil Diary 42368/2017.
कहाँ पर?
Top
कहाँ पर?
and 55 minute at page annexure 11 minute my short thing.
He has also referred to on the order passed by the Honorable Supreme Court in SLP within bracket civil bracket closed diary number within bracket S42368 of 2017 arising out of judgment and order dated 29/8/2017 passed in LPA number 50 of 2017 in turn arising out of CWJC number 7440 of 2013 passed by High Court of Judicature at Patna. The Learned Counsel submits that in view of the various judicial pronouncements, the petitioner is to be treated as an employee of the state government, and therefore the petitioner, having worked and attained the age of superannuation, is entitled for the service, for all the service benefits, including arrears of pay and post-retirement benefits. यही है आपका case. The Learned Counsel, appearing on behalf of the state while opposing the prayer, has submitted that on the face of Annexure 2, the petitioner was placed on deputation. He has further submitted that no order has been placed on record absorbing the petitioner in the services of the state government. It is further not the case, the petitioner is not even seeking any direction from this court for absorption of his services in the state government. The Learned Counsel has submitted that the petitioner was repatriated to Biscoman, and Biscoman also issued letter asking the petitioner to join, but the petitioner did not join and insisted on working with the Urban Development Department of the state. The Learned Counsel has further submitted that the judgments passed by the Honorable Supreme Court arise out of orders passed by Honorable Patna High Court with respect to different persons, and there is no material on record that the case of the petitioner stand on identical footing. He has also cited certain judgments passed by this court. The Learned Counsel submits that the petitioner is simply seeking a mandamus, and unless the entire facts are considered by the authority and an appropriate order is passed with regard to the status of the petitioner as to whether the petitioner is an employee of state government or is an employee of Biscoman, the mandamus prayed for by the petitioner may not be granted. The condition precedent for payment of pension and other service benefit is that the petitioner should be an employee of the state government. That's it. After hearing the Learned Counsel for the parties and considering the facts and circumstances,
He retired
from sometimes in the Achievement Corporation.
he continued to work throughout with you?
at the time of the retirement.
Sorry?
At the
He
time-
continued to work with you?
Under the direction of the UDD Urban Development Department, he sometimes worked with Achievement Corporation, and thereafter he was transferred to Jharkhand also.
And he continued to work under one or the other department of the state
Yes.
government?
In different places of the Jharkhand.
At the time of
The districts,
retirement.
so many
Certain
districts.
amounts from the Urban Development Department, thereafter we, as per the direction of the Urban Development Department, we returned those amounts to the department.
The learned counsel appearing on behalf of respondent number 4 has submitted that the petitioner had worked with the respondent number 4 for some time, but he was transferred from one place to another and had continued to work under the state government. However, the order of transfer are not on record. Is it on record?
No, my lord, I have finished.
All the orders?
Yes, my lord, the different places.
At the
my lord,
time of retirement, he was with RMC.
The petitioner attained the age of superannuation while working under respondent number 4. At this, counsel for the petitioner has submitted that the petitioner has placed on record all the orders of transfer
Yes.
and the details where the petitioner has worked
In different districts.
under the state government in different districts are already available in the writ records. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the core issue involved in the present case is as to whether the petitioner is to be treated as an employee of state government or he is to be treated as an employee of Viscomand. Unless such an issue is decided by considering the various materials, the prayer of the petitioner seeking mandamus upon the respondents with respect to his post-retirement benefits and other service benefits cannot be granted. However, the fact remains that the petitioner has worked for a long period, and it appears prima facie that the petitioner has continued to work under the state government
In urban development.
under urban development department right from 1994. However, this is also subject to verification of the records. In view of the aforesaid court dispute, this court is not inclined to issue the mandamus as prayed for by the petitioner at this stage, unless the status of the petitioner is duly determined by the respondent number.
Respondent number 2.
Respondent number 2, before whom the petitioner has already filed a representation as contained in Annexure 25 of the petition. However, the said representation was primarily for release of his service benefits. In view of the aforesaid facts and circumstances, this petition is disposed of, enabling the petitioner to approach respondent number 2 along with the writ records and a detailed representation annexing all the judgments which the petitioner seeks to rely upon. And upon such representation, the respondent number 2 shall, at the threshold, determine the status of the petitioner as to whether the petitioner is to be treated as an employee of the state government or an employee of Viscomand. For the purposes of arriving at such a decision, the respondent number 2 will take into consideration the various decisions passed, decisions which may be relied upon by the take into consideration the various judicial pronouncements as may be applicable to the petitioner. The respondent number 2, if so required, shall take the assistance of a government advocate. He needs an assistance. He will not be able to, while arriving at the decision, and pass a reasoned order after considering the materials placed before him within a period of 3 months from today. If the petitioner is ultimately found to be, the said authority will also take into consideration the case of other similarly situated persons which may be placed by the petitioner before the said authority with foundational details with respect to such persons. The reasoned order be passed within a period of 3 months from the date of the representation and be communicated to the petitioner through speed post. and if the petitioner is ultimately found to be an employee of the state government, there can be no reason to withhold the service benefits which the petitioner is otherwise entitled in accordance with law. This would also be subject to verification of the records of the petitioner. That's it. पहले डिटरमाइन कराइए, उसके बिना ये ऑर्डर नहीं हो सकता. Mr. Manish, there is one matter. Serial 5 में क्या है?
एज वाला मैटर था,
हाँ?
एज का मैटर था टर्मिनेट कर दिए.
अच्छा.
ये हमारा 44 साल 6 महीना होता है. इस समझ के 2070 में डेट ऑफ बर्थ समझ के तुमको
You have also filed.
वो हमरा नहीं.
अच्छा, जस्ट आपके अदर साइड कौन है?
हाँ यस
क्या है आपका?
तेरे पांच
क्यों आप
order
इनको परेशान किए हुए हैं?
परेशान नहीं किया होगा, इनका केस ही नहीं है, इनका 42 ही कंसीडर होगा, 45 वाला कंसीडर नहीं होगा.
क्यों नहीं होगा?
क्योंकि रिजर्व की बेनिफिट ऑफ रिजर्वेशन.
अच्छा, वो वाला.
हाँ, बेनिफिट ऑफ हॉरिजॉन्टल रिजर्वेशन ऑल्सो देयर.
आप तैयार है ना?
हम तैयार.
कल सुनते हैं.
हाँ कल
सुनते हैं. आज तो नहीं हो पाएगा, कल सुनते हैं. ठीक. कैलकुलेशन कहाँ से होगा?
हाँ, कैलकुलेशन कहाँ से होगा?
सबका ऐसे ही किए हुए हैं आप लोग कैलकुलेशन? औरों का भी इसी तरह से किए हैं?
So far this case is concerned, I am confining to the counterfeit and the materials because this is the policy decision of the state. That was
We'll
also that was also under challenge before. That I
We'll
know.
take it up tomorrow. आज नहीं हो पाया, कल करते हैं. Yes, Manish जी, और आपका
Yes, Your Lordship, last week I was not here, I am sorry for this situation. My
what is the corresponding rate?
My Lord, that is WPL 1023 of 2019.
1023 of
2019.
it is pending. What is the stage of this case?
Yes, it is pending. Mr. Mehta is filing.
Hearing में. Where is the other side?
My Lord, in the case which is listed before Your Lordship, last week it was recorded. Notice has been served to the workman, he has not appeared.
In that case, workman has filed it.
And in this case, workman has filed, yes, the second, right? He has filed it.
Okay, WPL number 3680 of 2019. Mr. Manish Mishra, advocate appearing for the petitioner, has submitted that arising out of the same award,
ID, please.
the concerned workman has filed a writ petition being WPL number 1023 of 2019, which is pending before this court. And in the present case, he has not entered appearance. Oppose this case tomorrow along with WPL number 1023 of
Well, if it
2019.
can be day after.
सिर्फ एक डेट ही देंगे, पूछ लेते हैं, वो वकालतनामा फाइल करेंगे,
I
नहीं
asked him
करेंगे.
today, he said I have no instructions in this case.
No instructions. Okay, day after tomorrow. No instructions in this case, but he has adequate instructions in the other
Yes, because
case.
here the workman has not bothered to contact him, Your Lordship. He has received notice, the workman has received notice, आएगा तब ना कुछ होगा. Day after tomorrow.
उसी में उनको डायरेक्शन देंगे कि अपना इंस्ट्रक्शन लेके फाइल कर दें, otherwise it will be decided expired.
Yes, ma'am. The other it is
Records
not-
आ गया इसमें.
इसमें आ गया. Last date Your Lordship has recorded in your.
अच्छा, records आ गया है, ठीक है.
Item number 50 date was fixed for today, that the date was given, but
Item number
53
53 कॉल आउट नहीं हुआ.
नहीं,
क्या है?
इसको कल के लिए रिड्यूस कर सकते हैं, ये परसों के लिए.
अरे हमसे इतना नहीं हो पाता है, बताइए क्या है?
उसमें था वो टिकटल अमाउंट था हमारे पर, वो रिकवरी के लिए सीजीएम ने ऑर्डर किया है विदाउट गिविंग एनी नोटिस ऑफ बीइंग हर्ड टू द पिटिशनर.
Where is the other
कभी हुआ
side?
ही नहीं था कमिश्नर के यहाँ.
Where is the other side?
अदर साइड उनको रिकॉर्ड के साथ मंगवाया गया था कि रिकॉर्ड के साथ प्रेजेंट करेंगे.
ऐसा ऑर्डर था यहाँ पर.
जी,
ठीक है, इसको भी कल ये सारा मैटर्स होगा, लेकिन कब होगा, किस समय होगा, ये कहना, लेकिन हम टेकअप करेंगे. आपका सीरियल नंबर 50 फाइनल डिस्पोजल में है क्या? ऐसे रेगुलर है, एडमिशन है. ठीक है, तो फर्स्ट हाफ नहीं आपका टिकट.